All right, good evening, everyone, and welcome to CCI Hironia's Intro to Condo course. If this is the first time you've joined us for an online course, welcome, and we're so happy that you've been able to join us today and check us out. If you are one of our repeat viewers, thanks for joining us again today. We've been very lucky to have with us today a group of our board of directors who are going to be presenting today's course. My name is Sonja Hodis. I'm one of the directors at CCI Hironia, and I'm a condo lawyer as well as your moderator today. If you want to find out any information about any of our other speakers, all you need to do is go to our website, ccihironia.com, and click on the About Us tab and click on the Board of Directors, and you'll find information about all of our presenters today. The purpose of today's webinar is to cover condominium basics. And we are going to be presenting a variety of important topics that everyone, whether you live in a condo, if you're a board member of a condo, if you work in a condo, if you're a property manager, we're going to cover the basic topics of things that you should know about. We're not going to have time today to go into a lot of depth in each of the topics, but we're hoping by the end of this course, you'll have a good overview of what it is to live in a condo and what it is to operate a condo. So if you are a property manager and you're joining us today for the CMRO credits, please make sure you put your name, first, last, and company name into the chat box. Please don't put it into the Q&A box. If you are a condo director or a condo owner and you are not on our mailing list and you would like to join, please send an email to admin@ccihironia.com. That way you'll be able to find out what's happening with within our chapter, and you'll find out about all of our upcoming events. I want to take this opportunity to thank our sponsors of today's webinar, because without the support of our sponsors, we're not able to offer these webinars free of charge to all of you. So thank you to our sponsors, Elia Associates and Common Ground Condo Law. All right, so starting us off today, we have Evan Shkolnik, who is our Vice President of our CCI Hironia Board of Directors, and Evan is going to give us a couple welcome words. Evan?
Oh, thank you, Sonia, and welcome to everybody that's joined us. Appreciate all of your attendance. We love to present to big groups. Just wanted to remind everybody, if you're not a member of CCI Hironia, we would love you to join. You can go to our website, click on membership. It's a really easy process. We have a lot of programs. So if you're a property manager and your board is not on, there's programs there to get on first year. Waiving the fees. If you're a condo director and you're not a member, ask your property manager and let's get you on board and part of the group. A lot of different resources from our website. We have our newsletter. We have our past seminar recordings that are easily accessible and shareable. So we hope you make use of that. Enjoy the course today. There's a lot to get through and a lot of great speakers to listen to. So thanks for joining.
Thanks, Evan. And if you don't know who CCI is, we are a national organization. We are a nonprofit organization that was formed in 1982, and we have chapters across the country. And CCI Hironia is one of the Ontario chapters. We've also been a multiple-time winner of the Lauren Young Chapter of the Year Award. And our main objective is education. And we also advocate for condos and all those in the condominium industry. We also like to encourage those that participate, from owners to directors to professionals, to work together and make condo living better for everyone else. If you'd like to find out more about CCI or how to become a member of our chapter or any other chapter, you can always check out the national website at cci.ca. And just a reminder to everyone that the information that's being provided in today's webinar is general information, and it may not apply to your specific fact situation. So under the Condominium Act, Section 37, which offers protection to directors, in order to use that protection, you do need to get an opinion about your specific fact situation from your own professionals. And if you're watching this webinar at a later date, because this webinar is being recorded, the information that is being provided in today's webinar is current as of January 28th, 2026. So if you're watching it at a later date, or if you're watching it outside of Ontario, please be sure to check with your professionals to make sure that the information is current. And all references to any legislation in today's webinar is to Ontario legislation. All right, so starting us off tonight, we have Ashley Winberg, who is going to explain what a condo is. Ashley?
Hi, everyone. So what is a condo? A condo, the word condominium, it describes the method of communal ownership of property. A condo can be residential, commercial, industrial, or even mixed. A condo is created when its declaration is registered. So that's when a condo corp is created. And when that happens, the condo corporation itself becomes a separate legal entity with its own common elements and its own assets. Some of the assets that a condominium corporation can have include cash, investments, and even units if the corporation is the registered owner of those units. These units can sometimes include parking or locker units, among many others. So the components of a condo are listed on the slide. So essentially, the two main components are the common elements and units. Corporations that are common element condominiums do not have units. They instead have pottles, which are parcels of tied land. But for condos, they have units. So when the corporation's declaration is registered, it's the common elements are created, as are the individual units. And when a person buys a condominium unit, they are buying their individual unit, but they're also acquiring an interest in the common elements and assets of the corporation in a percentage that's set out in the declaration of their condo. Some other components of a condominium include, well, obviously the units, common elements, and the common elements are essentially the property that is not defined as a unit. So everything but what is specifically a unit, which is determined by reference to a condominium's declaration and description. There are common elements that are used by everyone. And then there are exclusive use common elements that are specifically reserved in a corporation's declaration for the use of one or more units. And sometimes exclusive use common elements can be a parking space or a storage locker, a front or backyard, or a terrace, for instance. And I'm sure many of you have shared facilities. That's very common in the area. So shared facilities can be an amenity, which can either be a common element or an asset of the corporation that is often shared with another condominium or the adjacent property owner. These can include driveways or visitor parking or recreation centers. I will turn it over now to Justin.
All right, Justin, do you want to tell us about the different types of condos?
Yeah, for sure. Thanks a lot, Ashley. Yeah, so just go into a little bit more depth. So the four main types of condos that we have are standard condominium corporations, common element condo corporations, vacant land, and then leasehold condos. And then there's the kicker with the phased condominium corporations as well. So the standard condominium corporations are typical condos that many of you are going to be living in with the PSCC numbers or the TSCC numbers. And like Ashley mentioned, they're created when a declaration and a description are registered. And this has units and common elements. And it's funny, the description is defined more as what it isn't. And it's not a common element condo, it's not a phased condominium, and it's not a vacant land condo. And then talk a little bit more about the phased condos, which works its way into standard. So these have the ability to add units and/or common elements built in subsequent phases to the original condo corporation. The original declaration and description are amended to incorporate the additions. And then once all phases are complete, the condo operates as a standard condo. It's like, so a lot of people would be living in condos. There's a possibility that maybe you're in phase one or phase two of what a condo corporation would have been. And there's other lands that are there to build. And these are often what we see as phased condos. And it's to have the Terry-on warranty. So the phase condos that have at least one residential unit will have the protection by the Terry-on warranty. Now, moving on to the common element condo corporations. The numbers that we'll see associated with these ones will be like a PCE CC number, and there are no units in a common element condo. There are amenities, facilities, or services that make up the common elements. Examples of these would be roadways, sewage systems, and then rec facilities. So it could be golf courses, ski hills, or a rec center. These would be considered common element condo corporations. And the benefit of using common elements and the responsibility for the cost of operating are attached to the pottles, which are the parcels of tied land that Ashley was mentioning earlier with the common elements. And then for this, there's no warranty by Terrion. Vacant land condominiums, you'll see these often used by developers essentially. So there's no building or structures on the units at the time of the declaration and description. It allows the developer to build individual dwellings when the vacant land units are sold, or they can also have the purchaser or the builder build the dwelling unit themselves. So these cannot be leasehold condos or common element condos, but they can be phased. So you could see a vacant land condominium that's going to have several phases of builds kind of planned for the future. And then in the declaration, one thing that's different about these, it likely sets out restrictions as far as the type, the design, and the maintenance requirements of that condo corporation. And they must maintain common elements, the vacant land corporation must maintain common elements and repair damage, whereas the owners would be maintaining the unit, including the structures and the repair after damage. So you could see there's a difference in the responsibility for the original the vacant land corporation owners and then the unit owners themselves. And there is no ability to shift that responsibility. One other thing about that, just a quick insurance thing, is that purchasers would require a standard home insurance policy in a vacant land condominium corporation, as opposed to just the contents insurance that you would need in a standard condominium corporation, for instance. And then last but not least, the leasehold condo corporations. So you'd see a number like PLCC in something like this. The leasehold condos are developed on land not owned by the condo or its owners. So it's leased from an owner pursuant to a ground lease. These are typical longer leases, 40 to 99 years. And a lot of the reasons are to have more affordability. A lot of the reasons that leased land is used are going to be governments, churches, universities, hospitals, and they typically have a strategy that's not focused on the asset growth. So having the long-term lease is it just creates a different economic breakdown essentially for that kind of leasehold condo corporation. And a little stipulation is it automatically renews for 10 years at the end of the term, but there is little stipulations. The ground lessor can give a notice to terminate at least 5 years before the end of the initial term. And then if 80%, another stipulation, if 80% of the unit owners vote against the renewal, the ground lease will be terminated at the end of its original term. And thanks, guys. I'll pass it off to Sonja and the rest of the group.
All right. Thanks, Justin, for that overview. So now we're going to turn over to one very important part of condominium living, and that is the board of directors and their duties and responsibilities. And we have Patrica Elia with us tonight. Patricia, can you take us through these next couple slides?
Sure, not a problem. Thank you very much. Good evening, everybody. Well, the condominium corporation is not a corporate entity. It's a like in a typical business sense. It is an entity that's created uniquely under the Condominium Act. Condominium Act, of course, is consumer protection legislation. And as part of the structure, we as owners elect a board of directors. And that board of directors is governed by the Act, the DEC, the bylaws, and the rules. But there are some key important sections in the Condominium Act that directors need to know about. The first is Section 17. Section 17 sets out that the objects of the corporation are to manage the property and assets on behalf of the owners. So the stakeholders still factor in there, but just remember that the corporation has a very specific agenda. So we're controlling, managing, and administering the corporation, but we do so in the context of sections 27 to 41 of the Act, which set the minimum standard of operation by directors. And those sections, if you take a look at it, talks about the composition of the board, the election of the board, qualifications, etc., how we remove directors, what we do on vacancies. Section 37, though, is the real focus. And, we have to always take steps to ensure owners and occupiers comply with the documents. So that's section 119. You as a director have a positive duty to enforce section 119 and enforce compliance. And one thing that's important is that some people make the mistake of believing that even though there's a decision to be made by the corporation, let's say we need new windows, some people think that the unit owners have the right to vote on that. Typically, no. What we have to remember is that the board of directors actually has within its hands and its power the ability to make certain decisions for which no unit owner vote is made. And that is something to really understand under the Act, because the idea is to give that board of directors the ability to operate this corporation efficiently and make sure things get done. But I did briefly mention there Section 37. Section 37, though, talks about the standard to which we as directors must perform. And that is a really important standard that we focus on because, and Sonja mentioned it earlier, that when you execute your duty properly and you do get the right opinions, you are going to have directors and officers insurance to protect you, and you are going to be actually free of liability. So executing is important. But in Section 37, we have a duty to act honestly and in good faith and exercise care, due diligence, and skill that a reasonably prudent person would exercise in comparable circumstances. Over the years, that has evolved and taken on a lot of meaning through the common law. And it is not a matter of sitting there as a director and rubber stamping everything. It's fortunate that we have a lot of professionals, property managers that assist the board, but boards now are expected to really understand and manage risk and assess that risk and make decisions that make sense. You have a fiduciary duty. So if we could go back to the prior slide, the fiduciary duty is exercising that care, diligence, and skill. So when you're held to a fiduciary duty, you're held to a very high standard of performance. So our recommendation is always make sure your minutes reflect your thinking, that you've done the work, you've got the evidence, and you've made intelligent decisions in accordance with the Act. Next slide. We have to have board meetings, and this is a really key one, especially in the day of the internet and post-pandemic. The board is not permitted to transact any business of the corporation except at a meeting of directors at which a quorum of the board is present. So this efficient thing that a lot of directors do, which is zip across emails and say, do you agree, do you agree, do you agree? That's not a valid decision. It is not a valid decision until it is actually presented at a board meeting. So it has to be on the agenda, has to be presented, and has to be ratified. And the one thing that is really important here is that, when you have these discussions by email, sometimes you let things slip about people that you shouldn't have in the minutes. So what I suggest is when you finally decided what the resolution is going to be, put the resolution out there as a separate email and get those approvals and then have them ratified at the next meeting. Because that's what the court's going to look for, that you actually did it legitimately. If you didn't, it's not a legitimate act of the board. So if you agree and say, oh yeah, go sign that $6 million contract, but you don't have a resolution and then everybody backs away, you've got a problem. There's also the president and secretary who are mandatory officers, and there are other optional officers which you can look to your bylaws to find. Next slide. So good governance, this is a really key thing. You're managing multi-million-dollar assets. You have to be proactive. You have to have great communication with owners, rely on professionals where opinion is, where it's appropriate. Like Sonja said, if you get the right game plan from your legal professionals, you can go down the right path. But you need to also know your constating documents. And these days for directors, and this is not to scare anybody, but our scope of responsibility is bigger. Condominiums are, for example, workplaces now governed by the OHSA. You need to understand the implications of having a proper occupational health and safety policy. And that's really critical these days, that you have the critical policies in place and the rules to enforce those policies. Next slide. Over to you, Sonja.
Thanks. And thanks for that lead into the documents that we got to know about if we're directors. So this is, as Patricia was just saying, this is one of the most important parts um, of your job, is making sure you understand the documents that govern your condo. And so I'm going to take you through some of the key documents that you're going to find in your condominium corporation. When we talk about condominium documents, there's a hierarchy to them. So not each document has the same weight. And as you can see from the diagram that's on the slide, at the very, very top, and what has the most weight is the Condominium Act. And in fact, above the Condominium Act, there's one other piece of legislation that trumps everything else, and that's the Human Rights Code. So when we talk about governing docs, you need to have an understanding of what does the Condominium Act say? What kind of issues does the Condominium Act cover? And I find a lot of times when I talk to boards and to owners, the questions they have, a lot of times you can find the answers if you just go to the Act and read it. So make sure you become familiar with the Condominium Act. In addition to that, you also need to become familiar with your declaration. And the declaration, we call it the constitution for your condo. Every condo has a declaration because you can't exist without it. It's one of the requirements for a condo to be created. And the declaration is registered on title, and it's not necessarily the same for every condo. There may be parts of your declaration that are similar in other condo corporations, but there may also be sections that are different than other condo corporations. So make sure that you know what your declaration says. And then the next set of documents are the bylaws, and these are also registered on title, and they fall in the hierarchy, they fall under the declaration. So the declaration has more weight than the bylaws do. The bylaws have to be consistent with the declaration and the Act. And then under the bylaws, we have the rules. These are the documents that are the most flexible in terms of making changes to them. But you're coming down the line in terms of importance. They don't have as much weight as the bylaws and the declaration. They're not registered on title, and they can be created by the board, and they can be passed within 30 days if owners don't object. And other than the rules, we also have the policies, and Patricia mentioned some policies already. The Act itself doesn't refer to policies, so when we talk about policies, we have to remember that they're at the bottom of the hierarchy. They can't be enforced like a rule, a bylaw, or a declaration provision can be enforced. So they have their own purpose, and you need to understand the difference between what goes in a policy and what should go in a rule. And that's something that you should speak to your legal counsel about. So let's take a look at some of these documents in a little bit more detail. The declaration, some people say they're akin to the Articles of Incorporation. We usually like to talk about it being akin to the Constitution. They will have information about what you can use your unit for. They will set the boundaries for the unit, which is really an important piece of information that as a director, you need to make sure you understand what are the unit boundaries. They also have a very important chart as a schedule in the declaration, which sets out the percentages that are assigned to each unit. Those percentages are used to calculate the common expense fees that you'll be paying every month. It also represents your percentage of ownership. And the declaration is really hard to change. You can do it by owner consent, and depending on what you want to change in the declaration, you'll need 80 or 90% of owners to agree in writing to the change. And there are some circumstances where you can get a court order to change the declaration, but they're not meant to be easy documents to change. And as I said at the beginning, they are registered on title. Now, the next document that I want to just go in a bit more detail are the bylaws. Now, bylaws are approved by the majority of owners, or majority of units, sorry. And in some situations, depending on, again, what the bylaw is about, you may be able to get away with a vote that is less than 50% of units. Again, bylaws are really meant to address very specific things. Everyone will have at least one bylaw, and that'll be your general operating bylaw. And that usually sets out how how your condominium corporation is organized and how it functions. So you'll find things like qualifications for directors or disqualifications for directors in your operating bylaw. You'll find out the notice requirements. A lot of times that is where you'll see the percentage that is charged for as interest if somebody doesn't pay their common expense fees. It'll talk about the types of records the corporation is to keep. So there's a lot of organization and general operating information found in that general operating bylaw, but it's not the only bylaw that your condo corporation may have. If your condo corporation is borrowing money, you need a borrowing bylaw. You may have a standard unit bylaw, an insurance deductible bylaw. You may have a bylaw that deals with mediations and arbitrations. There's a variety of different types of bylaws that your condo can have. And again, not every condo has the same kind of bylaws. They are registered on title, and it's really important to remember that if you pass a bylaw, there's various steps that have to be followed. And the last step is it has to be registered. I've seen cases where condos have, the board has passed the bylaw, the owners have voted in favor of it, and then they forget to register. And if you don't register the bylaw, it's not effective. When it comes to the rules, we always say the rules usually deal with the 3 Ps, people, pets, and parking. But it also, deals with a lot of sort of the everyday rules that your condo may need and are very specific to your condo, dealing with cosmetic issues, like, for example, can you put things on your front door? Can you hang lights on your balcony? It will deal with things like noise and nuisance. If you have facilities, there'll be rules about the use of those facilities. So rules are, again, they're very easy to change, and they're meant to be easy to change so that they can adapt to your community as your community changes. But they do require the board to pass the rules and send notice out to owners. And then if owners don't requisition a meeting within 30 days, those rules are in effect. And then finally, just a reminder on policies. As I said at the beginning, policies can't be enforced like the rules, bylaws, and the declaration can be enforced, but they do usually provide procedures that help with how your organization, your corporation is run. So you might have a policy on late payments so that people know what is the procedure when you miss your payment. You may have a human rights policy, a discrimination policy, a harassment policy. There's a variety of different types of policies you can create for your condo. And there's nothing wrong with having policies, but you just have to remember that you can't enforce the policies. So if there is something that you don't want people to do, or you do want people to do, you need to make sure that those type of things get into your rules and are not just left in your policies. All right, and now we're going to move on to another important document, and I'm going to give it back to you, Patricia. You're going to talk about status certificates.
Thanks very much, Sonja. Well, status certificates are a very important document because they give you a snapshot of certain information about the corporation at a moment in time. And that's a very important thing to remember. A status certificate is only good on the day that it is issued. So it is an important legal document, and it can be requested by purchasers or interested third parties. It's supposed to be prepared within 10 calendar days from the date of receipt of request and payment. Section 76 of the Act talks about the status certificate, and management companies have no obligation, for example, to start the process of processing a status certificate until payment is received. Now, the biggest issue that we are seeing is that there is missing information or status certificates are incorrect. So it's really important that the details in the status certificate are accurate, that they identify the correct unit. For example, parking unit, locker unit, residential unit. Which unit are we talking about? Are there arrears? Are there no arrears? Because failure to put information in the status certificate will deem to mean that there is no information about that, and the corporation then will be bound by that statement. So let's say, for example, status certificate request is made, the deadline is not met, the the corporation is then deemed pursuant to the section of the Act to actually have issued a certificate that says there are no outstanding issues in these various categories, which is something you do not want to have out there as a status certificate. If you look at Section 76, we talk about a lot of different things, and there are prescribed components and additions to those to the status certificate. Now, one of the important things is not to add more than you're asked for. Sometimes there's a temptation to put in extra documentation. Our strict recommendation is stick to what is being requested, which is the status certificate and all the prescribed documents referenced in Section 33. So most status certificates are done electronically. A status certificate is not a full status certificate without the attachments. And, you also have to be very cognizant that if you know about something, for example, you know that there's a capital asset project coming, you don't know what the amount is, you haven't budgeted for it. There are sections, for example, Section 12 specifically of the status certificate, that should be modified to indicate that there may be a change to the actual common expenses for the unit, but that we don't know exactly what they are right now. And why do we do that? To prepare purchasers so that they understand what's happening. So in the case law, what we've seen is where there's been a failure to disclose that information, those unit owners or those individuals have purchased and then said, you knew about the special assessment. You didn't tell me that it was coming and I'm not paying it. And the courts have upheld that position. So it's a very important document to protect the corporation also going forward. So, like I said, if a status certificate is not prepared on time or omits information, then it's deemed to state certain things. So you don't give the status certificate, it means there's no default in payment of common expenses. The board has not declared any increases in common expenses since the date of the budget, and the board has not levied special assessment. This could be taking away very valuable resources from the corporation. So it is important that the content of the status certificate is correct and it's a snapshot. And the other secondary thing that is very dangerous to do, when somebody calls you up and say, you gave me a status certificate 5 days ago, can you just update it over the phone? Absolutely not. You say, would you like a new status certificate? Because the status certificate is only good for the day that it is issued. Hope that helps. Thanks, Sonja.
Thanks, Patricia. And speaking of records, there is a really important right that owners have under the Condominium Act, and that is the ability to request records from the Condominium Corporation. Now, there is a very specific process that is set out in the Act, and if you go to the CAO's website, you'll be able to find out information about that process. If you engage the process and you're not satisfied with the result, you can start a CAT application, which is the CAT is the Condominium Authority Tribunal. You can start a CAT application and have your request go through that process. And again, if you can't resolve it, there is an adjudicator at the end of that process who will make a decision about your records request. If you're a condo board, it's really important that you understand this process because it is mandatory and there are mandatory forms that have to be filled out. And so as a condo board or property manager, because those are usually one of the two people who are going to be receiving the records requests from owners, be sure that you follow the timelines that are set out. So if you get a records request, you must respond within 30 days and you must respond with the board's response form. So it's important that you use the forms that are mandatory, and the board response form is a mandatory form. Now, in terms of records being requested, there are going to be core records and non-core records. And we can do a whole webinar on just discussing what is a core record and what is a non-core record. But if you're dealing with core records, basically you're not allowed to charge any labor or photocopying fees for core records. And core records would be things like the governing documents, the minutes for the last 12 months, the audited financial, the latest reserve fund, study, those would be the core records. And some condo corporations, what they're doing to make things a little bit easier for everyone is they're putting those core records, like the declaration and the reserve fund study and the audited financials, on a web portal that only owners have access to. And so then owners can get those records without even making the request. So that's something that you can think about. You do want to make sure that those records are secured and they're not just open to the public if you are going to be posting them online. But that's another way to kind of deal with records requests. If you're dealing with a records request that has non-core records, then they're, depending on how those records are being requested, whether they're being requested in paper format or electronic format, there are certain photocopy charges that you may be able to ask for. There may be labor charges that you're able to ask for, but beware that when you're asking for these, the amounts that you can ask for are very small. And they usually don't actually cover the actual expense of having to produce these records. So just keep that in mind. And sometimes the thing that gets disputed the most on a records request is the charges that are being asked by the condo corporation. Now, at the end of the day, if the owner and the condo corp cannot come to an agreement on satisfying that records request, there is the process through the CAT, which gives you an opportunity to settle it on your own at stage 1, through a mediator at stage 2, or by an adjudicator at stage 3. So if you want some more information about requests for records, the Condominium Authority's website has a step-by-step guide on how to do the process. All the forms are available there. And again, don't forget, use those mandatory forms. All right, so that takes us through the first half of today's webinar, and we just want to take a moment right now to give our participants an opportunity to ask any questions. If you do have questions, you can put them in the Q&A box. If you want to ask your question live, if you raise your hand, I will promote you to a panelist and you'll be able to ask your question live. And again, I just want to take this opportunity to thank the sponsors of today's webinar, Common Ground Condo Law and Elia Associates Condominium Lawyers. Not only are they the sponsors of this webinar, but they are also our yearly education sponsors. So thank you to both of our sponsors. And if anyone has a question, either raise your hand or put your question in the Q&A, and one of our speakers tonight will be happy to answer it. I don't see any hands raised, and I don't see anything in the Q&A. I'm just going to look in the chat box in case somebody put a question there. All right. If I don't see any hands or any questions, I think we're just going to keep on going. Just remember, this is a great opportunity to ask questions. We will have another Q&A session at the end of the webinar. So if you want to ask a question, there's still time. You can put those questions in the Q&A box and we will get to them. Okay, so let's move on then. And Patricia, I'm going to give it back to you because you're going to talk to us about unit owner meetings.
Yes, thank you very much. Well, unit owner meetings are a very vital, important part of the condominium's evolution and life. Decisions get made at these meetings. One of the key components and one key meeting is the annual general meeting. The annual general meeting is, of course, different from regular owner meetings because the content is actually prescribed. We have to have certain things taken care of at these meetings. So the AGM has to be held within 6 months of the year end, the fiscal year end. So if you end in December 31st, you're having your AGM by the end of June. And the purpose of the AGM is to elect directors, present the audited financials, and take care of approving the minutes from the last AGM, for example, as well. Carrying out other business. We may carry out amendments to the bylaws, the deck, or talk about rules. So what happens is that the board approves the financials. Those are put in the package. And now, under our new structure, we get pre-notice of that AGM. And that means you as an owner get a heads up when that AGM is going to happen. You can make recommendations of content you'd like to have discussed. You can even make a recommendation that you'd like to have the board look at different auditors, and they can take that information. Then you get your notice, and in your notice, you will have your full package of materials that give you the agenda together with all the required attachments. As well, quorum for an owners meeting is 25% of all the owners of residential units in person or by proxy. So the electronic platforms that we use these days are really helpful in helping us gain that quorum so that we're able to do it. So you'll see in some of the older bylaws, there may have been a quorum requirement of 33 1/3%. That is no longer valid if it predates May 5th, 2001. Owners who are in arrears of their contributions for 30 days or more are not permitted to vote or count towards quorum. So if such owners pay their arrears before the meeting is held, and often I will allow owners to just pay it right there at the front desk by certified check, they will then be entitled to vote. Voting is done on one vote per unit. So even if units are owned jointly, one vote per unit. They can fight it out at home by themselves. So it's important that we hold these meetings and understand. If we could advance the slide. Another type of important meeting that we're seeing that has tremendous value is an information meeting. And an information meeting is a meeting where we are just actually having exchange of information. There's no voting. There's no formal notice unless the board wishes to have it. There's no need for minutes. But we're finding that these are very popular meetings to actually bring corporations and communities up to speed. But no binding votes can take place at this type of meeting because there is no formal notice. Next slide. And then there's always the fun meeting, the best meeting ever, the requisition meeting. The requisition meeting is a very interesting tool. It's a tool where unit owners can come together, gather signatures, and ask for a requisition and hold a meeting. And that can be for a variety of purposes. One includes removing directors or the full board, and putting other issues in front of the board now, or the unit owners. And so sometimes what you'll see is these requisitions come in to remove the board. You have to verify, make sure it's a valid requisition. People who are entitled to sign have signed. And then the board has a process and a time frame within which to call that meeting. If they fail to do so, then the requisitionist can actually bring the meeting forward. So what we like to do is when we see a requisition, we like to test it for its integrity and veracity and move it forward. Now, sometimes, though, in a requisition, we'll also get questions to ask for a vote on, let's say, the windows, whether the unit owners can vote on the replacement of the windows. That typically, because it's a common element, would not be a valid requisition meeting vote. So we wouldn't be having a requisition meeting to vote on that issue. But what we're finding is that when people have questions that come up in a requisition, the best thing to do is hold a meeting, understand why, explain what the issues are, get clarification, tell people why the requisition is invalid, but don't ignore it. So it's a really good way to actually create a good communication strategy with your community and help your community move forward. Next slide. So unit owner meetings, pretty practical expectations. Communicate, engage, and respect. Now, there's an art to chairing meetings. There is no doubt. I think Sonja has probably done several thousand by now. And she knows, and as has Ashley, we know that when you engage community, you have to have a very specific process on how you do it. You have to get the technical elements correct, but you also have to communicate very clearly with your community. You know, you'll hear residents complain. You need to know how to manage it, but you also need to know how to manage information in a way that actually is appropriate for the meeting. I like to see that unit owners all get the ability to speak and that I don't let people dominate the floor. I ask people to raise their hands, but then I also do my best to listen and make sure that questions are answered. And if I don't have an answer or property management doesn't have an answer, we do our best to circle back. So that's where, as you know, the quality of communication goes up and actually promotes harmony and strength in your communities. Um, but at meetings, when we get into unit-specific complaints, that's not always the best. We tend to shy away from that and say, we can take this offline and deal with your issues directly. I think that's it for me, Sonja.
Oh, there's one more, Patricia.
Oh, there's one more. Thank you. On the annual general meeting. So here's the timing issue. So you have to actually provide preliminary notice, and that has to be at least 15 days. And then you have to allow for at least 1 day of owner input. So it's a really tight timeline. If you see this aggregation of time, you have to be able to make sure you've met your pre-notice requirements, you get all the content in, make sure the package is done, and then have at least 15 clear days between your notice and the actual AGM. So it's very important that you actually do the math. And as you can see, when we calculate, we can end up with close to 37 days. So it's really important that when you're coordinating your AGM, you have your professionals ready, you've done your backwards calculation from the deadline date, and you get that pre-notice out in a proper time. Thanks very much, Sonja.
Thanks, Patricia. All right. So we're going to have Ashley come back, and some of you may be in a condo corporation that is managed by condominium management, or you may be self-managed. And so Ashley's going to talk to us about property management versus self-managed.
Hi, everyone. So the three categories that I'm going to speak about are condos that are self-managed, condos that directly employ a general licensee as a condominium manager, and that in condos, usually larger ones, and this is probably the most common, condos that hire a third-party service provider, which is a condominium management service provider, and that's a large property management company, large or small. So for condos that are self-managed, some condos are permitted to be self-managed if the management functions are carried out directly by the board, and no board member and no other individual is being compensated to provide condominium management services. And those are defined as tasks that involve financial management, common expense collection, record keeping and compliance under the Condo Act, coordinating repairs, organizing board and owners meetings, and acting as the board's agent. So if someone is receiving financial compensation for that, a board member or someone else, that is not permitted. Those type of tasks, if someone's being compensated, need to be performed by an individual who is licensed under the condominium CMRAO, who is a licensed condominium manager, either a general licensee or a limited licensee working for a condominium management services provider. So the second category is for a condominium corporation to directly employ a condominium manager, an individual. They can do this if that individual holds a general license and that individual is not directly employed by more than 3 condominiums, including that condominium. So 3 is the max. And if this arrangement is entered into, that must be done as an employee-employer relationship, not as an independent contractor relationship. And the individual must hold a general license. They cannot be a limited licensee. The benefits of this potential arrangement is that the corporation can have some control, a bit more control over the individual's salary, and as often will have the ability to choose the individual who is their on-site manager. Sometimes when hiring an independent property management company, you don't necessarily always have the ability to say who you would like to be your on-site property manager. So the third option is to hire a condominium management services provider, which is a property management company that directly employs general licensees as well as limited licensees. These companies usually have relatively strong back office support, experience, and industry insight. The benefits of hiring a company of this nature is that if your manager is ill, they generally are able to provide someone as support for when that person is absent, and they have oftentimes strong back office admin, which is critical. The drawbacks that they can be more expensive, a bit more pricey, and you can't necessarily have a direct say over who your manager is. That's often determined by the company itself. If you go to the next slide, please, thank you. So one of the things to keep in mind, regardless of whether you're hiring directly employing a general licensee or hiring a condominium management company, if you have a property manager, the board and the manager have related but independent roles of one another. The board is determining the corporation's policies, approving its budgets, and approving the projects. The manager is creating the policies and bringing them to the corporation, for review, the board for review and approval, and then implementing them. The manager is preparing the budgets and the financial statements and presenting them to the board for review and approval. And the manager is obtaining the quotes and again, presenting them to the board for approval. So the manager is kind of doing a little bit the runaround, but what the manager does has to be approved by the board because the board is ultimately the one making the decision as the corporation's elected officials. And I think I will turn it over to the next person on the docket now.
All right, thanks, Ashley. All right, so there's lots of things that both the board and management need to do in order to keep these condominium corporations running. And Patricia, I'm going to pass it back to you to talk a little bit about the annual plan.
Sure. Thanks very much. Well, the annual plan, I think it's really important for a board to have a vision. And for myself as a director, that's what I've seen is very helpful. We plan our meeting dates ahead of time. We have contract renewal dates marked in our calendars so that we know well in advance before we get locked into renewals of contracts that we've reviewed them. We've also looked at when our AGM would be because we work backward from that date to make sure that our auditor has all the documentation that's necessary in order to prepare those financial statements on time. As well, what we do in our annual plan is we also send out pretty standard notices that are seasonal to remind people of certain things to be done, whether it be HVAC cleaning, whether it be keeping your gardens tidy, whether it be understanding how to recycle. So it's important to create new routine and discipline for the corporation in the records of the corporation, because it also then evidences good governance by the corporation when it's called on for evidence as well. The other thing that we've started to add, though, to that annual plan is a review of policies. Policies, whether we like them or not, are going to be here to stay in some form for certain things. Like, for example, the OHSA policy, it's not an option. So interestingly enough, even if you passed rules to pass the rules for anti-harassment, anti-violence, and unit owners requisitioned a meeting to get rid of those rules, even if they were defeated, the policy would still apply. And I'm going to talk a little bit later about that because we have other laws that apply to us. But having that annual plan, knowing that you've actually reviewed your occupational health and safety, anti-violence, and anti-harassment policy is a perfect example of an annual review policy, because in that policy, you actually have to physically review the physical site for areas that could be of high risk. And that's very important these days for corporations to be identifying. So I think it's really important to actually create a master list that you do every year to make sure that the annual plan is executed. You can tick the boxes and you've coordinated any steps that flow from that with your manager or with your team. Thanks very much, Sonja.
Thank you. All right, and joining us tonight is Blair Spinney, who is the treasurer on our board, and he is the auditor, and he was just at an AGM presenting his audited financial statements. Blair, thank you for joining us tonight, and you're going to talk about money, budgets, money, and banking.
Thank you very much, Sonja. Yes, it was a very quick AGM. We had quorum, and I only talked to the board. So I guess first of all, let's talk about what is the financial responsibilities of board members. So Patricia talked about fiduciary responsibility of the board members and how that applies to the finances. I guess there's a few key things. First of all, they want to make sure there's sufficient amount of money there raised to operate the corporation in accordance with the Act and the Declaration, and also to make sure they set aside enough money for future major repairs and replacements. So there's two components there. Also, the board's responsible to ensuring that there's a system of internal controls in place to safeguard the assets of the corporation. And finally, the board is responsible to control and monitor spending. So let's see how that all happens. Now, the first sort of tool that the board has with respect to this is budgets. So the budget includes a budget for both the operations and the allocation for the reserve fund, and that's going to be talked about more in the next topic, and determines the common element assessments paid by the owners. So the budget is set annually and does not require the vote of the owners. The process begins 2 or more months before the year end, and uses the current year-to-date results from accounting to project the year-end amounts. The projection, along with other board plans and contracts, is used to come up with an amount for each line item in operations. The reserve fund study notice, again in the next session or next topic, is used to determine the amount to put into the reserve, and the total becomes the assessment for next year. Once the budget is approved, the board should send a budget letter and a copy of the budget to every owner. If it's going to be a large or unusual increase, the board should consider having an owners meeting. This is where communication is key. So again, this is a very important part of the communication process is the budget. Now, so we've got our budget set. Now, how do we collect the money? The industry standards is that owners pay by electronic withdrawals. So basically, we're using technology here to prevent fraud and error, and of course, to save time. Can use post-dated checks, but cash should never be accepted for common element assessments or any other payment owed by a resident or owner. Now, make sure that we collect the money. If the corporation defaults, the corporation has the right to register a lien against that owner's unit. So that's a powerful way to enforce collection through and can force a power of sale. So next thing, we've got our money in our bank account. Under the Condominium Act, the corporations are required to maintain at least one bank account for operations and one account for the reserve fund. So these fees should be collected monthly, and the amount related to the reserve fund transferred immediately after receipt. So now we've got our money in our accounts. We can talk about approving payments and check signing. Now, of course, these days, more and more people are going with electronic payments, but the principles still apply. So to ensure timely utility payments, these are usually just pre-authorized payments. But as far as check signing or other electronic payments, you should have a minimum of 2 signing authorities. And there's a couple options you can use. You can have 2 directors sign each check. And of course, that's going to be required if you're self-managed. 2 authorized office of the management company can sign each check, or 1 director and 1 officer of the management company. So if it's going to be 2 officers, I kind of recommend that there's some strong oversight by the board just to make sure they're seeing the amounts that are being paid by management. And of course, if there are electronic payments, the electronic payments in most systems, it's kind of a blur between invoice approval and the actual payment. So when I'm doing an audit and I look at an expense, I can usually see who entered the amount, who entered the invoice, the approval of the property manager, and as well as any officers and a director as well. I can generally see that in most programs. For proper financial risk management, the site manager should never be a signatory on corporation checks, because there's a bit of we got to make sure that there's segregated duties between the approval of the payment and people that are actually receiving goods or services. The other item I need to talk about is the financial statements. So now we talked earlier a bit about the budget process. So, and we've collected and spent a lot of money. So next we take a look at our financial statements. So these statements are usually prepared monthly by the management company, and all board members should receive a copy of the statement. At a minimum, the statement should include the balance sheet, the income and expense statement with a budget comparison, a reserve fund statement, an owner's arrears schedule, bank reconciliations for the operating and reserve bank accounts. Quite often, you'll actually have the actual bank statements in there as well. So this kind of completes the full circle for the budgeting process, because now the board's seeing the results of operations and being able to compare that to the budget that they had set. And they can adapt as they go along. If we're over in one category, you have to compensate somewhere else. So the other thing is to make sure that this is also something that should be documented in the minutes. The review of the financial statements, I should see that in anytime I'm looking at the board minutes on a monthly basis. So that's your internal financial statements. Now, external financial statements are the audited financial statements, or the ones that go to the owners. So there are some key differences. So generally, the owners don't have the access and knowledge concerning finances that management and the director has, specific to the corporation, that is. So these financial statements really require to have more information about the uncertainty that surrounds the corporation. So these are there's uncertainty with respect to estimates, contingencies, contingent liabilities in particular, and the risks that the corporation faces. Also, future cash flows is important to the owners. Details on the obligations for loans, as well as commitments. So generally, the biggest commitments are from the reserve fund, and sort of that can be sort of tied into the notice that I talked about earlier. Also, another key component of financial statements is that there's a presumption that they are at the transactions are at arm's length. So, in other words, the corporation is independent from the suppliers. And if that's not the case, it's the duty of the corporation to disclose any kind of situation where either the suppliers are related to either management or the management company or a director. So that's disclosed as a related party transaction. And of course, generally these financial statements are audited. So that's it for me. Okay with time.
All right, that was great. Thanks, Blair. And you mentioned reserve funds in your presentation, and now we have Evan back, who's going to talk to us about reserve funds and reserve fund studies. Evan? Oh, looks like we lost Evan. Evan, are you there?
He's not muted.
Is this working? I haven't
Yep.
There you go.
acknowledged.
You're,
Uh,
Evan is
I hit
back.
I am back. I apologize that. There's going to be a course coming up in April, going in more depth on reserve fund studies, but I wanted to make sure everybody left here with an understanding of the different three different essential components to every reserve. The first is the reserve fund. So that's a trust or an account that's set up by the corporation specifically to fund major repair and replacement of common elements and assets. That's its only role is to fund common assets and common elements and the repair of those capital costs. The second component is the reserve fund study. So the actual study, when in order to understand what we need to fund, we need to understand all the different components. We need to understand the current state of repair of those common elements. We want to look at the lifespan, what's required in order to keep them in a state of good repair. We project how much money will be needed and over what period of time either the repair or the replacement will take place. The Act requires every condo to get an independent reserve fund study, and that's done every 3 years. And there's different classes, class 1, class 2, and class 3. But the important thing is that these studies must be done by a qualified provider, an engineer or an architect, a certified reserve fund planner. And there's a number of different people that the Act sets out that can perform the study. So the study really tells you what needs to be funded, what components there are, what condition they're in, and when and how they're going to be replaced. And the third part is the actual plan, the reserve fund plan. We need to make sure that we have a strategy, a long-term strategy, to avoid running into negative balances in the funding of the reserve. We don't want to get to a point where we need to replace a common element and do not have the requisite funds in order to do that. Then we get a special assessment or leases. So the idea is you want to properly plan to make sure that the funds, as they're needed for those capital replacements and capital repairs, are going to be available. These contributions, they show up as a line in the budget under the reserve fund line. And again, as Blair said, the reserve is completely different from your maintenance. So if we have lots of money in our reserve and we need some extra snow removal, that's not going to happen. And we also can't use reserves for components that don't exist yet. So it was really warm summer. You can't build a pool if you don't already have one. So these are very, very prescribed. The major repairs and replacements of columns are paid for from the fund. and it's the only permitted use of that fund and it's the way to protect, to make sure the ongoing long-term viability of the condo and keeping it in a state of good repair. And I think those are the three main concepts. Thanks, Sonja.
Thanks, Evan. All right. So moving from reserve funds and reserve fund studies, we're going to talk about another big topic when it comes to condominium corporations, and that is insurance. And Ashley is going to take that topic. Ashley?
Hi, everyone. Insurance is a very hot topic. So under Section 99 of the Condo Act, corporations are required to obtain and maintain insurance on its own behalf, as well as on behalf of the owners, for damage to the common elements and the units, up to the standard unit, which I'll get to, for damage caused by major perils. Major perils include water escape, for instance, if someone's tub overflows, fire, vehicle impact. So, for instance, if someone's moving van hits the underground garage door, perhaps, as well as smoke, hail, vandalism, incidents of riots, and other prescribed major perils. So the corporation insurance will automatically kick in when a unit is damaged by a major peril. And for the remainder of this little chat, I'll talk about the example being water by a major peril. So under the Act, the corporation's insurance is only required to cover and repair the damage to that person's unit up to the standard unit. And that to determine what forms part of the standard unit, the Act states that for corporations, it's either the standard unit bylaw, if the corporation was created before the Act came into force in May 2001, or for corporations that have since been created, either the corporation's standard unit bylaw or a schedule that was schedule of improvements provided by the developer. We always recommend that corporations, even if they have that schedule from the developer, and even if the developer created a standard unit bylaw, that a corporation carefully review it and ensure that it really just stipulates that the corporation is only required to insure and repair the bare minimum of a unit if it is damaged by a major peril. And the purpose of that is to ensure that the corporation's insurance premiums and deductibles are manageable and do not unnecessarily increase. So a standard unit bylaw, that just lists the components of a unit that the corporation's insurance will cover if damaged by a major peril like water escape, and that the corporation will be required to pay if damaged, be required to repair if damaged by a major peril like water escape. The standard unit bylaw only comes into force when we're talking about an insurable loss and major peril, so fire, water. It does not change the regular repair and maintenance obligations set out in a corporation's declaration. And it also does not change the unit boundaries. It just comes into place whenever there has been an event caused by water, fire, smoke, what have you, that is defined as a major peril for which the corporation's insurance is deemed to apply. So, first thing to take away from this brief presentation is ensure your corporation has a standard unit bylaw, and if it does, please take a look at it to ensure that it is comprehensive and is really just the bare bones in covering the bare minimum. The second thing to take away from this brief presentation is the corporation under the Act, although it has to maintain insurance for the units and the common elements, if an act or omission of an owner caused the major peril, for instance, the water escape, that damaged their unit, the corporation can charge that owner back if an act or omission of that owner caused the water escape. And the corporation can charge that owner back for the cost of the corporation's insurance deductible or the cost of the corporation's repairs, whichever are less. There's another section of the Act that permits condo corporations to pass an insurance deductible bylaw, which permits the corporation to essentially charge an owner back if their unit is damaged by a major peril for the cost of the corporation's insurance deductible or the cost of repairs, whichever is less, provide as long as the major peril, so like the water, was not caused by an act or omission of the owner, by the corporation. And it's imperative that corporations have that additional insurance deductible bylaw in place. It is often very difficult to prove that an act or omission of an owner did in fact cause the damage, and then it's also difficult for corporations to charge the cost of the repairs or its insurance deductible back. So please review to see if you have a standard unit bylaw and if you have an insurance deductible clause. It's specifically section 105, subsection 3 of the Act in your bylaw as well. There are some other some other insurance that owners don't necessarily have to maintain under their declarations, but they should be encouraged to, and that includes their own insurance to cover unit improvements, so things that would not be covered by the corporation's insurance, as well as deductible coverage, insurance for theft and liability, as well as out-of-pocket expenses if they need to relocate. And this is a very comprehensive topic, and CCI, we are producing we offer a variety of different courses on this particular subject all year long. It's quite comprehensive. That's my brief presentation for now.
Thanks, Ashley. All right, so we're going to move on to the topic of enforcement, and I'm going to talk about this slide. So unfortunately, in condos, when you live close together with other people, there is always the possibility for conflict or issues to arise that need to be dealt with by some method of enforcing the rules that you find in your declaration or your rules or in the Condo Act itself. And so there are a variety of different ways that a condo corporation can enforce the rules. And I'm going to go through that very briefly in this slide. So before we get into what you can do under the Act or under your governing documents, I think one of the most important things to remember is that proactive communication is key. A lot of times people don't know what the rules are. You can sometimes be very surprised that people have lived in a condo for many, many years and they don't know what the rules of that condo are. People are not reading the rules, they're not reading their declaration or their bylaws. So it's important that you proactively communicate with your owners about what those rules are. And you can do that through newsletters. You can do that through a variety of different methods. Some condos have digital messages in their elevators or in their front lobbies that provide this type of information. But it's really important, if you expect people to follow the rules, that people know what the rules are to begin with. And just because someone's broken a rule, don't assume that it was done with the intent to break the rules. Sometimes they just didn't know what the rule is. So the first step in any type of enforcement is really good communication with the person, whether it's the owner or if there's a tenant, with the tenant and the owner, to let them know, hey, here's the rule, you've broken this rule, and give them an opportunity to comply. Now, sometimes that solves the problem, and that's great if that's the case, but sometimes it doesn't, and sometimes you have to escalate it to the next level. And when we talk about enforcement in condominium corporations, there's a variety of different venues that you have to choose from. And some of them are mandatory. So depending on what the type of dispute is, what the issue is, you may have to go a certain path. So there's three main paths. There's mediation and arbitration, which is a private process. You hire a mediator, you hire an arbitrator to either help you resolve it or to make a decision. So that's a private process. There is the court, the Superior Court of Justice is usually where you're going to end up going if you go to court. That is becoming less and less of a venue that people are taking disputes to. The court system has its own problems. It's not a very efficient way to resolve disputes. And then now we have the CAT, and I've mentioned the CAT before. The CAT is the Condominium Authority Tribunal. So it's a specific tribunal that has jurisdiction to deal with specific issues in condominiums. So I talked about the records requests. That's one of the things that they have jurisdiction over. So if an owner makes a records request, they don't get the response that they want, they can file a CAT application. The CAT also can deal with things like nuisances. They can deal with pets. They can deal with storage. So they have a variety of different areas that they can deal with, but they can't deal with everything. So you have to understand CAT's jurisdiction. So when you have a dispute that you're trying to resolve, the first thing is you have to figure out which route you're going to take. And that's something you're going to want to talk to your legal professional about. And then each of these processes have pros and cons. So sometimes you have the ability to elect, for example, to go to mediation and arbitration instead of going to court. And so that's, again, something that you want to talk about with your legal advisor about whether it is in your situation more beneficial to go the mediation arbitration route if it's an option and not mandatory versus going the court route. So for now, and for purposes of today's webinar, it's just important to understand that when you have to enforce your rules and you can't do it by effective communication, there's basically three routes that you can take. And depending on what the issues are, you may have to go to mediation or arbitration, or you can choose to do so. You may be able to go to court, and you might have to go to the CAT, depending on what the subject matter. All right, and I'm going to now pass it back to Patricia, who is going to wrap up today's webinar to talk about the other laws that affect condominium corporations. I mentioned the Condominium Act, I mentioned the Human Rights Code, but there's a bunch of other pieces of legislation that also impact us. So Patricia, take it away.
Thanks very much, Sonja. Yes, condominiums just don't live in a vacuum under their own Condominium Act. As Sonja has pointed out, the Human Rights Code talks about very important grounds of discrimination, which are not permitted. And where we sometimes find discriminatory elements in our declarations, for example, banning children from condominiums, that would be a breach of the Human Rights Code. It wouldn't stand up in court. And so that piece of legislation trumps. Another piece of legislation that it comes into our sphere is the Personal Information Protection and Electronic Documents Act, PIPEDA. PIPEDA technically applies to entities that carry on business. As you know, corporations that are condominium corporations are non-for-profit organizations. They do not carry on business, so they are technically not caught within PIPEDA. But we use entities that are actually business providers, they're service providers. They actually have to meet that standard. And when you look at Section 55 and you look at it very carefully, you will see that it really parallels the intent of PIPEDA. So our recommendation to clients is always to meet the standard of PIPEDA and have an information management policy that really talks about the use, collection, and disclosure of information. These days, it's becoming more and more important to understand the scope of the data that you're collecting. And secondarily, of course, you need to make sure that your service providers are protecting that data to a standard where you are not ransomed, that your data is not encrypted, and that your insurance policies actually deal with this issue. But it's important to have that policy in place. Another important piece is that the Occupiers Liability Act applies to condominium corporations. A condominium pursuant to the Act is the occupier of the common elements for the purposes of liability under the Occupier Liability Act. That means that when there's a slip and fall, the duty that's owed is owed by the corporation to individuals. So we have a responsibility as a corporation that we are making sure that when people enter the premises, that it's safe and that it's reasonably cared for. So when you see those slip and fall cases, immediately the evidence that's required is, of course, when did you last remove the snow? Were the mats down? What was the condition of the outdoor environment? And was the ramp on for those that have underground garages? So it's really important to be aware of this statute and how it creates liability. And the last one is the Occupational Health and Safety Act, which I've spoken about before. We are required and have been for a very long time under Bill 168 to have an anti-violence and anti-harassment workplace policy. And you cannot adopt the policy of your service provider. You have to have a policy specifically for your corporation. Why is that? Because your corporation in and of itself is a workplace. And condos are very unique in this regard because we manage several relationships at the same time. We have the relationship between the unit owner and the board and the supplier and the unit owner. A typical OHSA policy does not really adequately address that, but you have to manage those baskets in a very clear, transparent way and have a process in place on how complaints will be managed. So that concludes the discussion about some extra pieces of legislation, but it's really important to be aware condos are bound by the laws of the province of Ontario. So it is really important that when we do put things in place, that we are actually looking at any other applicable laws and making sure that it's binding on the corporation. Thanks very much, Sonja.
Thanks, Patricia. And before we get to our final Q&A period, I just want to highlight for everybody some of the upcoming events that CCI Huronia has planned. Our Lunch and Learn webinars are scheduled for February, March, April, and May. They're on Fridays from 12 to 1. The dates are up on the screen. February 20th is our next webinar. We're going to be talking about New Year's resolutions for condo land. On March 20th, we're going to be talking about legislative developments and updates. April 24th, we will be having our insurance webinar. We're going to be talking insurance. So if you've got questions about insurance, that's a great webinar to join us. And then on May 23rd, we are going to be talking about Stranger Things, managing the unseen and the uncertain. So that's going to be a great webinar. So I hope to see you there. You can register for all of our webinars on our website, ccihuronia.com. And all of our webinars are free thanks to the generous support of our sponsors. All you need to do is register and just do that right from our website. We also have 2 director certificate programs that we are running this spring. The first one is on March 11th, Governance Fundamentals, and April 22nd is Reserve Fund Fundamentals. So if you have questions about reserve funds, and you want to get a deeper dive into them, that's a great session to join. You can register for these courses online as well, ccihuronia.com. There is a $40 fee for these courses, which you can pay online. All right, so we have some time for questions. So if you do have questions, you can get them in the Q&A box, or you can raise your hand and I'll let you ask your questions live. We do have a couple questions already, so I'm just going to start those. Patricia, there is a question about the comment you made about 33 1/3 for quorum. Can you clarify that?
Sure, not a problem. You'll see that in some operating bylaws that are older, the quorum requirement for a meeting was specified as 33 1/3. When the new legislation came in, the one that came into effect May 5th, 2001, that changed that threshold to make it 25%. So thereafter, if you wanted to have a 33 1/3% quorum requirement, you would have had to have passed a new bylaw. Many corporations did not, and so therefore the act trumps. But sometimes when people are reading their operating bylaws, they make the mistake and reference an older bylaw pre-May 5th, 2001, and rely on that for quorum, but that would be wrong.
All right, thank you for that explanation, Patricia. There's another question. Evan, I'm going to throw this one to you because it's about the reserve fund. It says, is the board bound by what the engineering company provides for a reserve fund study, or can they determine the contribution amount? Is there a minimum and maximum contribution amount?
So a couple different things here. Is the board bound by what the engineering company says on the reserve? The board is required to get a viable reserve fund study, and that needs to be done by an engineer or one of the prescribed vendors that the act lays out. But if you get a reserve that you're not comfortable with, or you don't like, or you disagree, I mean, I'm hoping you're working with an engineer that you can have that discussion. But you're always available to get a different reserve, a different opinion, hire and get something else. Are you obligated to use that reserve? No. If you get another one and it meets the requirements, you can do that. But sorry, Sonja, the questions have gone. I'm trying to look at the other parts to that.
Is there a maximum and minimum contribution amount?
So the contribution amount, the percentage for each individual unit is described as a percentage in the declaration. So if we're talking about how much is required in the reserve to meet the plan, no, there's no maximum or minimum. You need to have at least a positive balance in your reserve fund. But how much that is, that's up to the reserve fund planner, the condition of the assets and the monies that are required. There are, tolerances that are in there. You might say the roof needs to be done in 5 years. Well, maybe it can go 6, or it's $500,000. Well, maybe it's 450, or maybe it's 600. There's play, but to say the maximum or minimum, no. Sorry, Patricia?
Yeah, I just wanted to add to what you're talking about there, Evan. Is that there is a requirement under the legislation to be fully funded. And even though that's a little ambiguous, there is a requirement that you are above a certain threshold in your reserve fund at all times based on what is projected to be expended. And so that you basically can cover your expenditures for the year and have money in your reserve fund. I think the other thing is too, as a board member myself, a reserve fund is a guide. We look at it and see if those projects that are prioritized for us are actually going to be the priority for the year. Typically they are, and it's important that we follow our reserve fund and spend when those assets are actually up for replacement. Sometimes you get a year or two out of them, and you've seen, especially because of the shortage of money, things being a little tight, people trying to find affordability solutions, maybe reprioritizing things. But that doesn't mean that the maintenance and repair obligation of the corporation and the obligation to repair capital asset disappears. It's just really in the board's hands, and the reserve fund is a guide to that. Where boards, I think, make a mistake is where they ignore the reserve fund and don't spend the money. It's not a savings account for a rainy day, as some people have referred to it. It's actually an active account to maintain the status of the assets. So there is actually a positive expectation by all unit owners that the money will be spent. So, for example, windows at the end of their life span, for example, at the end of 20 years, should be replaced, and they're probably well due. Any reserve fund planner worth their salt knows the truth of the information they're providing to you and should be able to stand by it. So I think it's really important to use it as a tool to plan, but understand that you're required, and that's one of the great things about Ontario legislation. You're required to save for capital assets. You look at Surfside, you look at Florida, where they didn't, and it's an absolute nightmare there. In terms of erosion of equity, demands on cash, because they didn't have these fail safes in place. So the reserve fund is a very important tool in our legislation.
And
A lot of times what we see, Patricia, is rather than boards not agreeing with the contribution levels, there might be a specific element. They're saying, well, we'd like to move that up, or we'd like to move the repair of that one back. And there should be some um, ability to work with the board and look at those priorities and manage those. For instance, the
Well,
reserve might say, do your lobby renovation in 5 years. Well, that's a different component than saying the roof and changing the timing or the money available for the roof. So we have to look at everything. But I think the concept of the question was, if they're not happy with the reserve, are they bound to do everything that reserve says? And I think, again, work with your planner, work with your property manager. But if you're really, really disagreeing, then get a second reserve to take a
oh,
look
I,
at those issues.
yeah, I totally agree with the second opinion, but I would also suggest that a reserve fund study falls into that category of proper due diligence, where a board should be relying on its professionals and using their opinion. So if there's doubt, absolutely get a second opinion just to bolster your own due diligence as a board.
And Blair, I just want to bring you into this conversation because as an auditor, what do you do when you see that the reserve fund balance isn't what the reserve fund study says it should be?
Well, usually that's a matter of timing, and I guess, yeah, and the changes in price levels too, right? If you had your study prior to COVID, and you know, everyone would have been offside, after the pandemic, before they had another update. And of course, there's a lot of sticker shock in that update. So I guess the point is, the reserve fund studies are due to be done every 3 years. So at the time the study's done, that's the best estimate of what needs to go in to fund the major, repairs and replacements. And that if prices go up, or the costs are higher, or they move things up, that's going to go up, and that will be covered in the next reserve fund study. One thing, though, the act covers, I think, because the question is, do we have to follow what the contributions are? So you certainly don't have to follow what the expenses are. That's something you monitor and should discuss with your engineer on an annual basis. But you're not required to spend the amounts that the engineers has projected in the study. But if you do commit to a plan, a notice of future funding, and that's sent to the owners, you do need to put that amount into the reserve fund every year. And you don't have to follow the reserve fund planner's contribution levels, but the notice actually highlights the fact that, the board has chosen a different plan than what has been recommended by the reserve fund study planners. So that's highlighted, and I look at that because that just kind of signals to me a higher amount of audit risk. And also remember that you're not, if a board chooses not to put in the amounts that are suggested by the engineer, you're not following the advice of professionals. And if you follow the advice of the professionals, the Condominium Act, I'm sure Patricia or Sonja or Ashley can tell me the exact section, but if you follow
37. Section
37, there you go. The act, I should know that. I'm not a lawyer. But if you follow the advice of the professionals, you can rely on the act to indemnify you. But if you don't, you're on your own.
All right. So if you don't see the contributions being made according to the schedule in the reserve fund study, then that's something that you're going to flag on your audit. Or
That's right. That's the other part too. Like, you can follow you can do, agree with the contributions, but then not do them. And then that's right in my audit report. for sure.
All right. Okay. If you want more information about reserve fund studies, join the director's course that we're going to be doing in the spring, because we'll be doing a much, much deeper dive. A couple other questions that have come up. Patricia, I'm going to throw this one to you because you talked about directors' responsibilities and governance and different types of meetings. What does an owner have to do if they are not happy with either one director or with the board themselves? How can owners remove the board once they're elected?
Well, you can bring a requisition. You can have the requisite 15% of valid unit owners sign a requisition and note that you would like to have one or more directors removed. And then there will be a requisition meeting and a vote held. And the vote has to be approved by a majority of all unit owners to remove. So that's 50% plus one of the owners to remove each individual director. It's not done en masse, it's done individually. And then usually in that same meeting, you will be able to elect the replacement individuals for the balance of their terms.
All right. Thank you, Patricia. And Ashley, I've got a question about insurance for you. What happens if a condo corporation doesn't have a deductible bylaw?
Well, the corporation doesn't have a deductible bylaw, and an owner's unit is damaged by a major peril. If, let's say, corporation thinks that owner did something that caused that major peril, for instance, that water to escape, the corporation will have to look at its declaration, often speak with legal counsel, and see if they can pinpoint that the owner was, in fact, guilty of an act or omission that caused that damage. And that's often difficult to prove. And that's why we recommend that corporations have insurance deductible bylaws, because it just saves you that hassle of having to prove that. And it's easier to charge your owners back that way.
Yeah, the other thing to remember too is that if you rely on the provisions in the Act that Ashley referred to, Section 105, if the damage goes to other units or common elements, you can't charge back. It's limited to damage to the owner's unit.
Yeah.
So the deductible allows you to extend the ability to charge back that deductible for damage going to other units and the common elements as well. So it's a really important document for condo corporations to have. So that's something, if you don't have if you don't have it in your bylaws right now, and if you don't know if you don't have it in your bylaws, I guess what you get to read tonight, check your bylaws and see if you have a provision for the deductible. And if not, you want to talk to your legal counsel about getting that in place. All right, this is the last chance for everybody. If you have a question, raise your hand or put it in the Q&A box. Otherwise, we're going to be wrapping up tonight's webinar. Thank you for joining us today. Thank you to our sponsors once again, Elia Associates Condominium Lawyers and Common Ground Condo Law. If you want to get any information about CCI Huronia, you can just go to our website, ccihuronia.com. If you want to get more information about any of our speakers tonight, again, just go to our website and go to the About tab, and you'll find information about speakers who are all part of our board of directors. And I just see another question popped up. Oh, thank you, Lloyd. Good job to everyone. Thank you for that. And don't forget that today's webinar is being recorded. So if you missed some of today's webinar, or you want to go back and listen to certain parts, or you think there's someone in your condo who might benefit from watching this webinar, it's going to be posted on our website and on our YouTube channel in the next 7 to 10 days, so you can watch it there. And while you're there, check out some of our other webinars that have been posted. And if you're on our YouTube channel, please subscribe. We would love to increase our subscription numbers. Always feel free to leave a comment on the video or give us a thumbs up. And don't forget to share those videos with others. So we're going to wrap it up tonight. Hope to see you at one of our upcoming webinars. Our first webinar is going to be on February 20th. Register on the ccihuronia.com website. Thank you to the board who joined me today. Thank you to all of you for joining us. And if you are a property manager and you haven't got your name into the chat box, you've got 5 seconds left to type your name very quickly and your company name so that we can record your attendance. So thank you everyone for joining us tonight. Have a good evening, and we'll see you at one of our upcoming webinars.